So the idea that I had when writing my foreign relations law book was that I wanted to investigate all the rules and principles that govern the external exercise of the public power of the state. And I looked especially at the four closely related Commonwealth countries, New Zealand, Australia, Canada and the UK. And I was trying to tackle three sets of issues. One was, how is the foreign relations power distributed between the three organs of government, the executive, the legislature and the judiciary? The second is, what's the impact of the exercise of the foreign relations power on the rights of individuals? And the third, how do we treat foreign states within our own domestic legal system? And I got to thinking that this whole area was somewhat under-researched. It sort of falls between two stools. It falls between public law on the one hand and international law on the other. And yet that's the sharp end where many of these most difficult questions actually arise, precisely because domestic courts have got the powers to exercise which can lead to these cases arising, and it's because also it's after all national governments that have the principal role in implementing international law within their national legal systems. But if you look around for a book to deal with this subject, what you'll find, at least in the UK and the Commonwealth, is relatively little. Some 30 years ago, a short book called Foreign Affairs in English Courts was written by the famous mid-20th century international lawyer F.A. Mann, whom I was privileged to know in practice in London, and there'd been essentially nothing since. So I was working on a greenfield site, but while I was doing the research, so many of the issues with which I was concerned became really hot issues in national legal systems. But even if we just take some very, very recent examples, the whole debate about Brexit in the United Kingdom is really a debate in the first instance about which of the organs of government actually have the power to decide when and under what conditions the UK should leave the European Union. The timing of the publication, I think, turned out to be rather important because it's come out just at a point when a lot of people in government, in the relevant countries, in the judiciary and in academia are very much concerned with trying to address these issues. And what they all needed was some kind of template, some structure within which to put the disparate sets of nevertheless very pressing questions that come up. The Law Foundation's role is particularly important in the academic setting in New Zealand at the moment because although there are some other sources of funding for large-scale research in law, there isn't nearly as much funding available for law as there is for some other areas, in particular in the sciences. And yet, without this kind of funding, this kind of very ambitious research work simply can't be done. One of the reasons why New Zealand continues to have a highly successful legal system, which in turn contributes significantly to the health and welfare of our polity and society, is because we continue to retain capacity to think for ourselves about the way in which the law should be structured and the way in which it should be made to work better for society. Of course, there are many elements that contribute to that, but one is the sort of deep thinking that can be done by scholars engaged in large-scale research. And in a whole range of ways, the New Zealand Law Foundation supports that project. And I've seen that myself, not only in the work that I've done through the big projects we've been talking about, but through the smaller conferences and seminars that it supports, and through very valuable support that it provides also to younger colleagues here in the faculty and elsewhere around